Good afternoon and welcome back, everyone, from the lunch break. I'm Commissioner Cindy Jeffries. I will facilitate the discussions this afternoon. And with that, we will move directly into the financial responsibility issue paper number 4. Greg, do you want to walk us through that?
Sure. So we'll just go through, as we recall from our discussions in January, the department has removed and reserved 668.15 and moved the relevant parts of it into the financial responsibility. Excuse me, the rules under subpart L. So let's go and past all that and left all those strikes, and we take it over to on page 8. We see we'll start with compliance audits and financial statements at the bottom of that page. So let's start there. It's 668.23. I'll wait for Vanessa to get there. There we go. Fantastic. Okay, so we're going to begin at 668.23, compliance audits and audited financial statements. And we're pointing out here that you see under A4 that in response to questions from negotiators about timing, we have revised the language to clarify that audit reports must be submitted by the earlier of 6 months after the end of the institution's fiscal year or 30 days after the later of the reports on compliance audits and audited financial statements. So you see that reflected there in the language in 4, and submission deadline, except as provided by the Single Audit Act. An institution must submit annually to the Secretary its compliance audit and its audited financial statements by the date that is the earlier of 6 months after the last date of the institution's fiscal year, or 30 days after the date of the later auditor's report with respect to the compliance audit and audited financial statements. So just want to make that clear. And we'll move down, discuss all these as one section because it's not very big. So let's move down to audited financial statements in D. You see here in subparagraph 1, we have added a sentence requiring disclosure of audited financial statements to attest that there are no related party transactions. If that is the case, this will provide more clarity and greater assurance to the department that the statements were comprehensive. We also propose additional edits to address challenges the department may have in obtaining adequate and comparable information about institutions that are owned by foreign entities or entities or individuals. This change requires the submission of the date of the organization, certificate of good standing, and an authorizing statute for the entity status, as well as other information the Secretary may require translated into English. So you can see the reference to third-party related party transactions, rather, at the bottom of D1 there. So just to where it says if there are no related party transactions, then a footnote must be added to disclose this fact. And then the other point you see in Romanet 2 for domestic or foreign institution that is owned directly or indirectly by any foreign entity or individual holding at least 50% voting or equity interest in the institution must provide documentation of the entity's status under the law of the jurisdiction under which the entity is organized, to include at a minimum the date of organization, a current certificate of good standing, and a copy of the authorizing statute for such entity status. The Secretary may also require the submission of additional documents related to the entity's status under the foreign jurisdiction as needed to assess the entity's financial status. Documents must be translated into English. So that is everything for 23. Open it up for discussion on those points.
Okay, I need to make a couple notes here. David Sokolow is at the table for the state higher ed executive officers and agencies. And Adam Wella is back in for state attorneys general. So with that, Jamie, you have the floor. You're on mute.
I apologize, that's a holdover.
Oh, okay. Emmanuel, I see a note that you have a question taking us back to gainful employment. Is it possible that you could submit that for the department so that we can move forward with this rather than reopening discussion on gainful employment?
Sure. I think I more so had a comment because I felt like we weren't completely done with that before lunch, but I can always share it later.
I'd appreciate it so that we can try to get as much of this covered so the negotiators can get their perspectives out to the department on the issues. But just feel free to send it to me and I will send it immediately to the department, okay? Thank you for that. Other discussion on 668.23 in financial responsibilities. Okay, I'm not seeing any hands. Greg, you want a temperature check on these changes?
Sure.
Okay. If I could please see your show of thumbs, that'd be great. Beverly, I can't see yours. There you are. All right, I'm not seeing any thumbs down.
Okay.
Okay.
Given that, we'll move into a discussion of, we're moving into subpart L, and we're moving into section 668-171 general. It's up there on the screen. Thank you, Vanessa. And so we moving down to B3. I want to point out here that there was some comment about in B3 where the institution is able to meet all of its financial obligations and provide the administrative resources necessary to comply with Title IV HA program requirements. The institution is not deemed able to meet its financial or administrative obligations if, and one of those was it fails to make in, I should say in Romanet 3, it fails to make a payment in accordance with an existing undisputed financial obligation. So there were some questions about that we want to address here. Just to say, we believe this event already includes failure to pay state payroll taxes, as that was brought up at the previous session. And we appreciate the partnership of our state regulators. However, we do not think we should imply the provision might be narrower than it is by mentioning only one such example in the regulation. So I wanted to point that out. And also in Romanet 4, we've slightly tweaked the language here to further clarify our meaning, but don't consider this to be a substantive change. So take a look at what we did in 4. Just it fails to satisfy payroll obligations in accordance with its published payroll schedule. And moving over to 4, there's no change there. And we did have a suggestion to include past ownership as an executive or officer of an institution whose closure resulted in the closed school discharges of at least 10%. And while we appreciate the suggestion, we note that the outstanding liabilities are already covered in the regulations if closed school liabilities have been repaid. However, we are not persuaded that the circumstance applies under financial responsibility. So that's a very short, obviously a very short section there under B, but I will in the interest of trying to go by paragraph and stick with that, I will open it up for discussion for that and then take a temperature check.
Okay. Brad, go ahead, please.
Just really quick, and I mentioned this week one, but just for the record, I strongly encourage the department to relook at the composite score. It is set up to encourage institutions to do financially dumb things that are hurting students and costing more in tuition. So to have financial responsibility with no composite score review is unfortunate, and we really need to take a look at that very soon. Thank you.
Thank you.
Thank you, Brad. Other comments from the negotiators? Okay, I want to note that Kelly Perry is back at the table. Welcome back, Kelly. Barmack.
Yeah, my only comment is that in enumerating specific markers of a failure, that, one could conjure up all kinds of other equally as troubling things, right? I mean, an institution would not be financially responsible if it were to take on massive debt that it doesn't have adequate resources to take on. I understand the construct, but it just worries me that you're enumerating a subset of specifics without being particularly comprehensive or setting up a broad universal rule, of which these would be illustrations.
Thank you. If you have other suggested text, Barmack, you're welcome to submit it.
Thanks, Barmack. Anyone else? Before we do the temperature check on 668.171B. Okay, seeing none, can we go ahead and see your thumbs on that 668.171B? Oops, my screen switched there. I'm not seeing Kelly. Okay, I'm not seeing any thumbs down. Oh, Johnson, you have your hand up.
Yeah, I'm sorry. I'm joining late. I just got
Oh, okay.
off of an airplane. I apologize for all this.
No worries.
But, so I was, one concern I've had, and this has to do with transcript withholding, is I've essentially seen this as a tool to keep people enrolled in schools, which I think obviously the schools need seats filled, but I had suggested earlier in our submissions that be a sign of a lack of financial responsibility when that is being done to keep students at school. So I just wanted to bring that issue up again. I think it occurs here. The Consumer Protection Bureau criticized ITT in a suit for keeping students at the school by using their inability to move elsewhere with transcript withholding on relatively small debts. So I had suggested that earlier on, and I just want to note that for the record here.
Okay. Thank you for that, Johnson, and please drive safely.
I'm kidding.
From the airport. So since Johnson joined and didn't have a chance to weigh in on the temperature check, let's rerun that one more time, and that's on 668.171B only. Okay, so we have one thumbs down. And Johnson, just confirm if that was for the reasons you just stated.
Yeah, absolutely.
Okay, all right, great. Then we can go ahead and move on. Appreciate it. So Greg, you want to take us into paragraph C?
Sure. Let's, there we are, paragraph C. So we're moving into the mandatory triggering events. And just to set this up, an institution is not able to meet its financial or administrative obligations under paragraph B3, Romanet 5 of this section if, and these are mandatory triggers, and couple of things to discuss here in response to concerns from negotiators about the administrative burden associated with the and this, I should talk about the trigger here first. After that, we're looking under Romanet 1A. After the end of the fiscal year in which the secretary has most recently calculated an institution's composite score, if the institution's composite score was less than 1.5, or any described in this subsection, the institution is required to pay a debt. And I won't read through all of that, but in response to concerns from negotiators about the administrative burden associated with this trigger, we have narrowed it only to institutions with a failing or zoned composite score, or institutions that see an outcome of one of the events in subparagraph B related to state, federal, or certain qui tam lawsuits. Also, and then we'll move down to B. If the institution or any entity whose financial statements were submitted in the prior fiscal year to meet the requirements of 66823 or in the year following a change in ownership, the entity following a change in ownership, the entity whose financial statements were submitted to meet the requirements of 600.20 G or H is sued for financial relief or in an action brought on or after July 1, 2023 by a federal or state authority through a qui tam lawsuit, or in which the federal government has intervened and the suit has been pending for 120 days. So here we are further clarifying the language to reflect that it includes the institution or any owner whose financial statements were relied upon to meet the financial responsibility requirements, including for a change of ownership. And we added a comma there where at the bottom where it says, or through the qui tam lawsuit with the federal government has intervened, comma, and the suit has been pending for 120 days. So just want to point that out. And then moving down to Romanet 2, withdrawal of owner's equity. We have slightly tweaked the wording in this section, deleting the words from the institution, which are unnecessary, and adding general partnership to clarify the application of the exception. We also clarified this refers to the institution or its owner. So there you can see that reflected withdrawal of owner's equity for proprietary institution whose composite score is less than 1.5. There is a withdrawal of owner's equity by any means, including by declaring a dividend, unless the withdrawal is a transfer to an entity included in the affiliated entity group on whose basis the institution's composite score was calculated, or the equivalent of wages in a sole proprietorship or general proprietorship, or a required dividend or return of capital. And then we're going to move down to changes with respect to gainful employment. So that's Romanet 3. We have proposed a new trigger that requires institutions to post a letter of credit if they have a failing GE program with Title IV volume, or I should say failing programs with Title IV volume that totals at least 10% of the total Title IV volume, since the failure of those programs and the subsequent loss of the Title IV eligibility to the program could lead to a significant financial loss for the college. And next, I move down to 4, which is teach out plans. At the suggestion of negotiators, we have added an additional condition, or we've added additional conditions in which the accreditors are required to obtain a teach out plan in the regulations. We believe these are major events that warrant financial protection to students. So you can see that reflected for the institution, Romanet 4. The institution is required to submit teach out plan and or agreement for a reason described in 34 CFR 60224C1 and C2 Romanet 2 through 5, if that covers the closing of the institution or any branches of the institution. And going to look at 5, Romanet 5, state actions. The institution is cited by a state licensing or authorizing agency for failing to meet state agency requirements, and the agency provides notice it will withdraw or terminate the institution's licensure or authorization if the institution does not take steps necessary to comply with that requirement. And I don't want to take I'm not going to take a temperature check here, but I want to stop here because we've gone over quite a few of these, and I want to give people an opportunity to comment while they're still fresh in folks' minds, and then we can move on to the remainder of the mandatory triggers.
Okay. With that, we open it up for discussion. I believe we're on paragraph A of, well, A under paragraph C of the document up to, did you end at?
I ended in
Romanet
Romanet 5. I ended in
Right,
Romanet
yeah.
5.
Yeah, that's what I thought.
State action. So we'll take it through there, and then we'll continue with them. But I just want to give people an opportunity to.
Sure. No, I think that makes sense. And there was actually some requests to break it down a little bit more like this for discussion. So appreciate that. Dave, you were up first.
Yeah, I have some just logistic kind of clarification questions as an auditor, how this would work. And Greg, I can share those now. If you want, I'll wait until negotiators share their questions. Either way works for me.
You may bring those up, and also please put them in the comments. I mean, put them in the chat.
Okay. Yeah. So under Romanet I, about the recalculation of the composite score, just as an auditor, raises questions. So I don't know, the composite score gets calculated based on audited financial statements that get submitted to the department. So would a recalculation also require a new audit in order to be submitted, or how would that function?
I will take that back to our accounting people, David. So
Okay.
if you put that in the remarks, and I'll make sure I get a response to
I
that.
will.
I
Yep,
just want to make sure we run it by people who have
Greg,
been
I don't
appropriately
mind-
trained. Oh, do you want to?
I don't
address
mind
that?
trying to answer that one for Mr. McClintock. It does not trigger a new audited financial statement. It would be a calculation where that adjustment was applied to the prior, most recently completed audited financial statement, is my understanding.
Okay, and then if it's getting applied to that financial statement, we'll need clarification about how that would flow through everything. So are you just adjusting equity or the unrestricted net assets? or
See, when you
prior
go more
period?
than one question deep, then I have to take it back.
And I'll put it in the chat. So obviously the composite score incorporates the entire activity of a school for the
Right.
year ending on that date. So a single event after, and just saying to recalculate doesn't really provide instructions for how that would be done. And then the other just clarification question I think that I have for now is further down under section B about the institution to recalculate composite score or in the year following a change in ownership. And in particular for the year following a change in ownership, the change of ownership, the financial responsibility is measured based on the opening balance sheet ratios. And so the entity would not have a composite score to recalculate. So there'll just need to be some clarifications, and I can put both of those in the chat.
Hey, Greg?
Thank you.
Thank you.
Thank you.
All right, thanks, Dave. Just a couple changes at the table. Samantha Vitter is back at the table for financial aid, and Yael Shavit is now in for State Attorneys General. And with that, Yael, you are up next.
Thank you. Apologies, I'm going to ask you to walk me through something slowly. Can you walk me through the significance of the change to Romanet IB?
I just think which one
It's the submission of financial statements with respect to the use of filing of a state enforcement action as a triggering event.
see if I can. You're talking about the institution or any entity whose financial statements were submitted, that
Yes.
begins there? Oh, okay. All right, so you're talking about the, here we have added clarified language to reflect it's the institution or owner whose financial statement were relied upon to meet the financial responsibility requirements, including the change in ownership. So just to review, the institution or any entity whose financial statements were submitted in the prior fiscal year to meet the requirements of 6/16/23 or in the year following a change in ownership. The entity whose financial statements were submitted to meet the requirements is being sued for financial relief in an action brought on or after July 21, 2023 by a federal, state agency or authority rather, or through a key TAM lawsuit. This just as there a specific, I mean, this would be to account for where there is an action on the part of any state or federal authority, or where there's a key TAM lawsuit that it would be a mandatory triggering event.
Sorry, the language that you added, I thought I'd heard you say that it was intended to be limiting language to address concerns about administrative burden. And so I was wondering how that actually functions.
For this one here, I don't believe this was a burden. This was a burden issue. This was just to clarify to reflect that it includes the institution or any owner whose financial statements were relied upon. So
understood. That's helpful.
That's all we're doing here.
Thank
Sorry
you.
about that.
No, I appreciate it. Thank you.
Just spoke on that.
Kelly, you are up next.
Thank you. Greg, I was hoping you could help me understand I've read it like 6 times and I'm really struggling. So I think what I'm reading is that for institutions whose composite scores were less than 1.5 and they're required to pay a debt as it relates to B or C, if then recalculated and it's less than 1, then it's a mandatory trigger.
So talking in A, after the end of the fiscal year for which the secretary has most recently calculated an institution's composite score, if the institution's composite score was less than 1.5, or the institution described in subparagraph B or C of this section is required to pay any debt or incurs any liability from a settlement or final judgment determination arising from an administrative proceeding, as described, as a result of the debts, liabilities, or losses that have stemmed from these actions or events, the institution's recalculated composite score is less than 1.0 as determined by the secretary. So this would be if the way and Steve can step in here, if the institution's score was less than 1.5 and these proceedings would these as a result of these debts, it would go below, it would go to less than 1.0. It triggers the event. But I'll let Steve comment on that.
And that's my understanding too, Kelly.
So it's only for institutions that already that are in the zone or failing that would then push them below a 1.
It'd take
That would
them
be
out
the
of the zone.
trigger.
Right.
Correct.
Steve, I noticed you had your hand up before Greg.
I'm going to
also addressed it.
I just wanted to get in line.
Okay.
I don't want to disrupt anyone ahead of me.
Okay,
Thank
great. Thank you. Brad, you're up next. There you are.
As I just am baffled here as the accountant on this committee, how this is going to work. It's similar to Dave's question, but I mean, at the end of the day, how are you going to go back in time and run something through your P&L to calculate the equity reserve and throw something on your balance sheet that occurred after the fact, you're not going to submit a new financial statement in the easy audit. I just think the department throughout this thing is setting themselves up for a train wreck on submitting these items as they occur. And then who's responsible for calculating this? You're going to have CFOs certify, you know, the department isn't going to have all the information of the new financial statements in the easy audit until the next year's audit is done. So I think administratively, this is not going to work. And so, but I did want to comment on 1A. I appreciate the language that was incorporated. I still think, and throughout this document, I still think there's a materiality threshold. I'll submit back in the chat, but I think using a threshold that we've used throughout at around 5% of Title IV is a good mark to insert probably in all of these comments. So I'll stop there, get back in line and come back with my B comment, but y'all are setting yourselves up for an interesting process in the department over the next few years. Thanks.
Thank you, Brad, for that. Barmack?
I just put in the chat a question about C1 Romanet 1A, Kelly's, the topic of Kelly's interest. I don't understand why this should be limited only to those institutions that happen to be in the zone. The institution could have a spectacular composite score. If it drops below 1.0, that sounds to me like that's trouble. So that's one. The second question I had has to do with Romanet 2, withdrawal of owner's equity. If I understand the Cap A and Cap B provisions, they work in tandem with each other. And it sounds like you, if you allow the payment of equivalent to wages or required dividends or returns of capital to exempt the institution from the provision of A, that you would allow those payments to drop an institution below 1.0. Am I correct? Just because you know, setting up required dividends is not that hard, right? You just draft a contract on the front end and then don't worry about your composite score because you can drop below 1.0 and it was required payment, so you're off the hook.
Okay. Thank you, Barmack, and thank you for putting those in the chat. Steve, you are up next.
Okay, thank you. I was just going to, I'd gotten some additional information for that responding to the question that Mr. McClintock was raising, which is part of the proposals in this package will result in a composite score being calculated based on the new owner when there's a change of ownership. So that score would be recalculated under these provisions. And I understand the comments have already been made about the difficulty of taking a subsequent event and using it to recalculate a score, but mechanically that's how this would fit together.
Thanks, Steve. Go ahead, Dave.
Okay, I'll put it in the chat. I think it's a little bit different. I would need to know the logistics for how do you recalculate it. If the school operated and submitted a year's worth of financial statements to recalculate the composite score. But schools that undergo a change of ownership, it might be a new company, right, that bought a school. So they don't have a composite score necessarily from the prior year. The department does say, okay, on the date of ownership, you have to submit a first day balance sheet. And there's two, the asset test and the tangible net worth test to determine the financial strength of that institution at that point in time. But there is not a composite score to recalculate. So I'll put it in the chat. That's the question for that.
Thanks, Dave. Carolyn?
Yes, I shared Barmack's question about restricting Romanet 1A to institutions with a composite score of less than 1.5. It seems to me that limitation doesn't make sense because we're talking about schools that because of this change would have a score of less than 1. So to me, it seems like excluding schools that started off in a good position and ended up in a failing position doesn't make sense if the goal of the regulation is to identify schools that are not financially stable, that the outcome is important, not where they started. And I would strongly suggest that be changed to get rid of the 1.5 requirement.
Thank you. We'll take that back.
Thank you, Carolyn. Brad?
Yes, I submitted in this in my previous comments, but in I guess what was B under Romanet 1 on the entities that have a lawsuit filed. You know, I think it should be struck. I have a significant problem with every time a lawsuit is filed, that potentially being a mandatory trigger when the event and the judgment has not occurred yet. And whether or not it's even material is not even defined in this section. So you're saying that if a institution gets sued for $100 and they have a composite score of less than 1.5, that could be a mandatory trigger requiring a letter of credit? Is that what I'm reading here?
Well, I would point out that we, in that section that we talk about and let me just find that again, sued for financial relief brought on or after July 1, 2023 by a federal or state authority, which is generally concerning. We're not talking about, garden variety suits for $100 here. We're talking about a federal or state authority bringing a suit against an institution or a KETAM lawsuit, the nature of which is also concerning to us because of how broad a KETAM lawsuit is. So I don't think that we are looking at it in terms of, every small claims or suit or something somebody might make. But I'll ask Steve to elaborate on that since he's our attorney.
I'll just add to that question then, I guess, as written, not Greg's opinion, as written, if you're sued, regardless of the amount that you're sued for, it's a mandatory triggering event.
It's again, I say it's not Greg's opinion, it's how it's written. I mean, so it's by a federal state authority or through a KETAM lawsuit. So I think there are qualifiers there around that. It doesn't say in this instance any lawsuit. I suppose it would be possible for a federal or state authority to sue an institution over something very minor. I certainly don't think that would be the norm, or that federal or state agencies or authorities would use their resources for something insignificant and minor, though I don't want to speak for those entities. But since this is a legal matter, I'll turn it over to Steve.
Oh, I think we've got other people at the table that can speak to that.
Well, okay, well, then we can let them speak as well. But that would be I don't really have much else to say on that topic.
But my recommendation is just add a materiality threshold. So I'll add that to the chat.
Thank you, Brad, Greg, and Steve. Yeah, you are up next.
Greg, share your skepticism. I am not aware of a $100 lawsuit brought by a state AG's office or a federal enforcement body. And more than that, I will note that the injunctive terms that go along with the types of lawsuits that we bring against for-profit schools have significant financial significance to those institutions as well. But it's just not, it's not based in reality, right? When you look at the history of state AG actions against proprietary schools, what you end up seeing are lawsuits that will drag out for a long time, despite the fact that the financial risk is present from the moment of the lawsuit. And what typically happens is that after we are ultimately successful, the school will declare bankruptcy like the next day, right? And it's just not realistic to prevent the harms associated with those financial obligations to wait until the moment that there's a judgment in those lawsuits. It's just also not consistent with the care with which state enforcement bodies and federal enforcement authorities enter these types of lawsuits, right? I think that the moment that the actions are filed is the moment when the risk becomes evident, and it's completely appropriate at that moment to look into to require an institution to take actions to ensure its financial obligations.
Okay, thank you, Yael. Kelly, you're next.
Thank you. I'm under the debt liabilities and losses. If we're making the assumption that B and C by themselves are mandatory triggers, I'm not sure why we need A. Because it's basically saying debt and liabilities that come from B and C. And if B and C are already a trigger, why do the debt and liabilities have anything to do with it? Another way to look at it in response to Brad's question about materiality is you could look at A as the materiality threshold for B. Because you're saying if you're going to recalculate the score and it's less than 1.0, that's the trigger, but then B alone can't be a mandatory trigger itself. I just feel like we're kind of in a circular reference here.
I do want to point out that in A, we have the institution's composite score is less than 1.5 described in this section, is required to pay any debt incurs any liability from a settlement. So this is all inclusive of any liability or settlement, whereas so that has to have been incurred. Whereas in B, for instance, which we were just discussing, it is the trigger has been sued by or had an action brought by the federal state authority or key 10 lawsuit.
But I thought you said before that the debt and liabilities in A had you narrowed it to be only from B and C. So B is already a trigger. Why do we need A?
Well, because again, it's because as the result of the debts or liabilities that have stemmed from these actions. So I view that A as being speaking to the liabilities, debts that have resulted from a result of these actions. Whereas in B, the action itself is a trigger. Well, I don't know if Steve, do you want to elaborate on that or?
Yeah, I think Kelly's suggestion is that this is circular, and I think we need to take a look at it.
Yeah, we'll certainly go back and take it. Kelly, if you'd like to make put that in writing, that would be helpful for us to take a look at.
Thank you, Kelly. Brad, you're next.
I'd just like to point out in response to Yael's comment that that every year in our audit, we have to do legal letters and we actually assess the likelihood and materiality of all lawsuits and book those as accruals on our balance sheet. And those are a part of our composite score every single year in our audits. And it's not like states have never lost a lawsuit before. So let's remember that. On gainful employment, wow, this was added. Where is the 10% coming from? And just a simple answer, Greg, is 10%. That's the first time I've actually seen a number in financial responsibility. What would a school normally do if they lost 10% of their revenues?
I'm not sure I understand the question, Brad. What would a school do?
I'm just asking where the 10% number came from.
Oh, where the
on Romanet 3B.
Let me just look at that again.
If that's the materiality threshold we want to use, then let's use it throughout this document.
Yeah. Well,
I mean, it's interesting that we now put a materiality threshold in one particular section.
I'll get some clarification on the 10%. I'm not 100% certain at this point where what exactly we based the 10% on, but I will get that for you.
Well, I'd like to propose that if that's the threshold, we use it throughout this mandatory triggering event section in every single comment. But I'll tell you, as a financially responsible CFO, if you lost 10% of your revenues, you'd cut 10% or more of your expenses to cover that loss. And so I would look at income here and not revenue. But again, 10% is fine for me to use throughout this document. I propose 5. So.
Okay.
There you go.
Okay, yeah. Jessica, you're next.
Thanks. I just wanted to briefly respond to Kelly and what I see as the importance of A, B, and C under number 1. Again, if I'm understanding it correctly, which may, the department should feel free to correct me, is that we're talking about 3 different kinds of claims, all of which, we see in my office. One is an individual claim or group claim by any private person out there against an institution. And for that in A, I think that only is a financial trigger under pretty limited circumstances, which is the liability has been incurred, like the case has gone to judgment or to settlement, and that it would have a material impact on the composite score. I think that B and C address situations that are separate from that, which is either that a state or federal authority brings an enforcement proceeding, or the borrower defense claims in C. And I guess I just want to support all of those as being important financial triggers. I think the first one is really clear that if the school has incurred the liability and that liability would have an impact on the composite score, then there's a really clear connection there. But I do think that B and C are also very important. I think there are both direct, as AIL said, and indirect implications for a school's financial status if they're sued by a state or federal regulator or have a high volume of borrower defense claims. And I think, those are sometimes overlapping categories. Like we sometimes bring claims that the New York Attorney General will bring at the same time, but they're often distinct. And I think it makes sense that the department should treat them differently. So.
Thank you.
Okay, thank you. Brad?
Yeah, I've got another question here. So, these mandatory events that occur after your fiscal year end, the composite score is as of the last day of your fiscal year. And schools, whether you like it or not, across all industries, they make sure they have enough in their equity accounts to cover the financial score at the end of the year. And so my question is, if an event occurs subsequent to the fiscal year, are you then going to allow schools to do a contribution into equity to make sure they're still covering that score? I just am not following how this is going to work.
Thanks, Brad. Any other comments going up through Romanet 5? If not, Greg had indicated he was not stopping for a temperature check. He's just trying to break this down in smaller chunks for discussion. So Greg, you want to pick back up?
Yes, we'll pick up with Romanet 6, publicly traded entities. There we have it. That's good. We've clarified the language here in this section to refer to both institutions and their owners. We also added a reference to foreign exchanges to account for institutions listed on the foreign exchanges that may face similar actions, and you see that reflected. Publicly listed entities, an institution that is directly or indirectly owned by at least 50% by an entity that is listed on a domestic or foreign exchange is subject to one or more of the following events. So just making that clarification there. And the next one we have changes to, if we move down to 9, the loss of eligibility. In 9, loss of eligibility, Romanet 9, the institution has lost eligibility to participate in another federal educational assistance program due to administrative action against against the school. And this is at the suggestion of negotiators during the last session. We have added this mandatory trigger for cases where an institution's eligibility for another federal education program, such as VA programs, is terminated. When we further clarified this trigger to reflect it in oh, sorry about that, wrong thing. So let's that was in 9, and then down to 10, an institute contributions and distributions. An institution's financial statements required to be submitted under 66823 reflect the contribution of at least reflect a contribution in the last quarter of the fiscal year, and the institution then made a distribution during the first 2 quarters of the next fiscal year. And the removal of such contribution up to the amount of the distribution results in a recalculated composite score of less than 1.0 as determined by the secretary. We have further clarified in this trigger to reflect that, to include rather contributions that are in an institution's financial statement. And then moving down to Romanet 11. This is creditor events. We have added an additional trigger to address major creditor actions, such as a default or another condition as a result of an action taken by the department, and the termination, withdrawal, litigation, or suspension of a financing arrangement with the institution. So that's under creditor events. I'll read that: as a result of an action taken by the department, the institution, or any entity included in the financial statements submitted under 668.23 is subject to a default or other condition under a line of credit, loan agreement, security agreement, or other financing agreement, or any creditor terminates, withdraws, limits, or suspends any line of credit, loan agreement, or other financial statement. And then we're moving down to 2, the bottom of the page. Here we have proposed language to clarify the timing and application of this requirement, which exists in current regulations, that financial responsibility discretionary triggers become mandatory if 2 or more hit. So in 2, we'll see here that in the fiscal year following the year in which the secretary has most recently calculated the institution's composite score, if the institution becomes subject to 2 or more unresolved discretionary triggering events as defined in paragraph D of this section, which we'll get to shortly, these events become mandatory triggering events 60 days following the second triggering event if both triggering events remain unresolved. All further discretionary triggering events during the fiscal year become mandatory triggering events, even if both of the original triggering events are resolved. And that takes us through the end of mandatory triggering events under C. So I'll open it up for discussion on the ones from 6 through the end, through 11, and also 2. And then we'll take a temperature check.
Okay, great. Thank you, Greg. Jamie, you're up.
Thank you. I'm returning to this fascinating subject of 2 discretionary triggers becoming mandatory. And it feels almost like this provision has become more complicated and harder to understand. If you could explain what resolved means, and if that's something the secretary always gets to on a consistent and quick basis, or whether the time could run, they're not resolved, and they become mandatory, even if they are harmless or irrelevant. So without recognizing Barmak's suggestion that we not think of the infinite outlier possibilities, I'm picturing an institution where a Katrina or a typhoon has affected enrollment, but no indication that it's financial, and or a planned, intentional, wise closure of a number of programs, both of which are discretionary triggers. But forcing the secretary to have to go through all that list, or the institution in fine shape is suddenly in mandatory trigger land, seems unreasonable. So is there a problem about discretionary triggers that the department has seen that it's trying to solve with this? Or is there a chance for unintended consequences or mischief that that could be handled in a simpler way to address the need that you actually have? I'm just not understanding why two harmless or innocent things need to be made mandatory triggers, but if the department needs that authority, maybe we can do it in a more tailored way.
Yeah, I mean, as written here, yes, you're correct that the two discretionary events become, makes it mandatory even if they're resolved. And what we're looking at here is, our concern that if even if triggers are discretionary, if they're coming up, that's an indication that there could be an issue at the institution. I do take your point that they could be relatively minor. You pointed out they'd be relatively minor in scope, and that could trigger the mandatory event. Your concerns over that, so we'll definitely take that back. If you have any suggested language to clarify this, or to make it that you think might preclude that situation from happening, we'd be happy to take a look at it.
If I could just follow up, if the department could explain what the risk is that it sees, I'd be happy to work with you on language. If it's a discretionary trigger, the department always has the ability to say, it's discretionary, we looked, it's troubling, you're triggered. So the same amount of time to decide whether it's resolved or not, it can spend to say, Katrina wasn't your fault, but you are now in, but we are looking at the expenses that were generated. We have to look at financial responsibility, so we are triggering whatever the next steps are. The department has the ability to say there's a problem. So I don't understand why it needs this provision this way. Happy to work with you offline.
Okay, sure. We'd be happy to take that back.
Thank you, Jamie. Brad?
It's the contribution distribution. It looks like it's 16, Romanet 16, but I can't, my eyes right on that. It's right after loss of eligibility, right after number 9.
That's Romanet 10. That's Romanet 10, Brad. It's just so many strikeouts and everything. It becomes like the I's and J's and L's eventually. Yeah, they all appear to be the same. Yeah.
Thank you. I'm just trying to figure out if this metric here, because it's A and B together, and I'm trying to understand, is it a cost, say just use a round number. If you contribute $1 million in the last quarter of the fiscal year, and then you take out $3 million later to pay your taxes, is it just the $1 million that's subject to this? I'm trying to figure out why the contribution is even listed if really the goal is just to say any removal of equity that brings you below 1.0 is the issue. So help me on the contribution side of that statement, what that means.
Well, the trigger is intended to account for a lot of situations we've seen where institutions make these contributions in the last quarter simply to shore up their financial position, and then immediately go in and remove that amount of money. And that's why the removal of such contribution up to the amount of the distribution results in the composite score being 1.0 or less, or being less score of less than 1.0, because we're looking at where they put the money in and just went and took the money out. So I mean that's what it's meant to account for. And then as a practice we see quite frequently the making a contribution simply for the purpose of meeting meeting the composite score requirement.
Got
So
it.
that's why it's in here for the last quarter, and then so made that distribution, and then made it so financial statements reflect the contribution made in the last quarter of the year, and the institution then made a distribution during the first 2 quarters of the next year. So clearly, it's tied together.
Tied together.
Those things, right? And that's to look for to try to control for a very real problem we see with the gaming of the statements.
I'm good if it's tied together, so I think you answered my question. Creditor events, the next one down, I guess that's 11. I'm struggling with this one and why it's mandatory. I mean, banks can pull a line of credit for really anything. I mean, a line of credit is, especially one that's unfunded, is really nothing. If you don't fund a line of credit, if you don't withdraw money in a line of credit, a lot of line of credits, they just pull from you because they're losing money if you just got an open line of credit with no actual debt pulled out of that line of credit. So why would we be concerned that if a bank takes an unfunded line of credit away from a school, why would we be concerned that's a mandatory event that requires a letter of credit? Is that right?
The event, again, here we have I think it's important to point out in Romanet 11A, this is as the result of an action taken by the department. So where the department, for instance, would take some action relative to the school, such as perhaps placing the institution on HCM1 or HCM2, and as a result of that, they're subject to a default condition on the line of credit, or that line of credit is pulled. That could certainly affect the financial situation of the institution.
Why does it say or between A and B then? I take that as B stands alone. Am I reading that wrong?
No, A is as a result of the department. That is as a result of the department action, the institution or any entity included in the financial statement or subject to a default, and B is separate from that. Any creditor terminates. You're asking, does it all stem back to as a result of the department's taking action against the institution?
Right.
That's
the question. Is A and B tied together, or is B stand alone? It reads like it stands alone, and terminating a line of credit should not be an issue. That happens every day.
I'll take that for clarification. Steve, do you know the answer to the definition of that, or should we get clarification?
We'll take that back for clarification, Brad. The instances I'm aware of have been predicated on actions the department has taken that's caused banks to shut down access to funds, and they have triggered very precipitous actions by some institutions.
I just recommend taking out the or and putting an and. I think that would be appropriate.
Okay, thank you. Kelly, you're up.
Okay, couple of things. One, I agree with what Jamie was talking about as it relates to the triggering events, even if resolved, will trigger a mandatory. So I would be more than happy to work on language if I can understand, like Jamie indicated, what you're trying to accomplish here. In the contributions and distributions section, and I brought this up last time, with all the conversations that are happening, it sounds like this relates more to proprietary institutions than it would private nonprofits. But a couple of questions. One, it talks about the institution's financial statements submitted reflect a contribution in the last quarter of the fiscal year. I guess the first question would be, how are you going to determine that it's in the last quarter of the fiscal year? Because the financials don't break down information on a quarterly basis. And two, as it specifically relates to private nonprofits, the terminology of contributions and distributions could be extrapolated to mean contributions from donors and distributions of what, I guess. So I just feel there needs to be some more clarity around this, if it's specifically meant to cover contributions of equity and then the debt distribution out. And then the third thing is, and I know I passed this section, but the insert of the gainful employment trigger, I just want to say that depending upon where that lands, this could be of concern if there's not a appeal for making sure that the data that it's being evaluated on is correct.
Thank you. We'll take back your concerns on definitely on the contributions and see what we can provide some clarifying language there.
Thank you, Kelly. I want to note Adam Welly's coming back to the table for State Attorneys General. With that, Barmack, you are up next.
So several comments. First one on Romanet 6, publicly listed entities. I see what you're attempting to do here, but what if the institution itself is listed? I realize that there are holding companies that may be publicly traded, but there are also institutions that are publicly traded. So you may want to modify that. Regardless of what you do there, under Cap A SEC actions, it's a nice sentiment, but you're closing the barn door after the horse has bolted by the time that kind of axe comes down. So you may want to be more expansive in terms of adverse SEC actions that could trigger something. The exchange action is okay. The SEC reports are okay. What is missing, which actually is quite relevant to past history, is significant and precipitous drops in market cap. Now, if we had the composite score under consideration, that might be answerable there, but since that is not there, and now we're in the unfortunate position of enumerating bad outcomes, a significant and precipitous drop in market cap is probably a better indication of trouble than all of this stuff that you've listed here. So that's one. I've already referred to this on loss of eligibility, Romanet 9. Institutions, the Department of Education is the only agency where the entire institution is either in or out. The VA allows programs in or out. So loss of eligibility should be more fine, because this will be meaningless as is drafted. It should be if one of institutions' programs has lost eligibility to participate, if one or more have lost eligibility, programs have lost eligibility. That just makes it more meaningful. And finally, to creditor events, first of all, I actually agree with Brad that, termination of credit in itself is not a sign of trouble, right? But my problem is with Cap A. As a result of an action taken by the department, well, what if they defaulted without your action? That's okay. It seems to me like you want to drop. You don't want that as a conditional there. It shouldn't be as a result of anything you do. It should be in general. If an entity defaults or violates the terms of a line of credit or a covenant, that should be a trigger. And one last comment, once again, because we don't have the composite score itself under consideration, this too is closing the barn door typically when the horse has bolted, because it's really at the point where debt is taken on, where unmanageable debt is taken on, not when they begin to default on it. That a decent creditor would, say, hang on a second, we had a covenant that you shouldn't be leveraged beyond a certain level. I don't know what we can do about that, but if we're not going to open up the composite score, at the very least, you may want to have some coverage ratios, some statement here. Thank you.
Thank you.
Thank you, Brady. See, Brad, you're next.
I was going to let Beverly go in front of me. She's been trying to raise her hand on the video, and I think she was before me, if that's okay.
Beverly, do you not have the raise hand function on your
I
screen?
didn't see. I just raised my hand. I overlooked it. No problem though. You're going first.
Okay. Well, the only thing is we don't want to overlook you.
No problem. No problem.
Our eyes are trained to look for those little hands up in the corner,
and I see it,
and I might miss you. So please feel free to interject.
I apologize. That's why I said it's not a problem. And
no worries.
Let me just say I agree with comments made by Jamie and Kelly, as well as Barmack. But I want to speak briefly. I'll ask a question briefly about this accrediting agency actions. I don't think anyone has raised that. What's the intent here? Is this something that the department would do before a final decision by the accrediting agency? Because generally speaking, having a show cause action, probation or warning sanctions don't, the institutions can correct that. They're given an opportunity to respond, and within a 2-year, 3-year period sometime. And I wanted to I'm not sure about the intent there, but it may not be a problem, but it could be problematic.
Okay, thank you.
Yeah, well, I will take that back and get a response.
Okay, Brad, you're up.
On the to discretionary becoming a mandatory, I believe that whole section needs to be struck. I know we haven't got to discretionary triggers, and we'll hash through those here in just a minute, but the fact that many of them are still undefined, you can then require a discretionary trigger. I just think that is a letter of credit tied to some of the ways these discretionary triggers are written is just would be completely wrong. And I'm also curious, how does 60 days come about? Like, what is that? And I'm in number 2 there on the 2 triggers, discretionary becoming mandatory. Where does 60 days come from?
It's a reasonable period of time following the triggering event. I don't think it's key to a specific reference, but I will check. It's a reasonable amount of time.
Oh, so it's am I reading this right? So you have one, and then 60 days later you have a second. That's what triggers it. But if it occurred within 60 days, it doesn't. Am I reading that? I'm just trying to help me out.
All right, we can read through it again. So it's the institution becomes subject to 2 or more unresolved discretionary triggering events as defined in paragraph D of this section. Those events become mandatory triggering events 60 days following the second triggering event if both triggering events remain unresolved. So that just means that 60 days following the second triggering event, it gives time for the resolution.
So the first one could be 360 days unresolved, then, if I'm correct on that, as long it's the trigger.
It's the second triggering it's the second subject. Those events become mandatory events 60 days following the second. So the first triggering, the second triggering event, so you have two of those discretionary triggering events, and then we have the first one occurs, and then the second triggering event occurs, and then they become mandatory 60 days following the second triggering event if both triggering events remain unresolved.
And so how do you unresolve high annual dropout rates?
Yeah, I'm not certain as to how one would do that. That occurred. That's correct.
So that's forever if it's occurring. All right. Well, I just think it needs to be struck. Thank you.
Thank you, Brad. David, the advisor, Dave McClintock, you have something to add?
I just have a question I think that might have been raised as a consideration. I want to make sure I understand. Barmack was saying, if a school borrows a large amount of money, that is going to be considered a trigger. And just, schools, all kinds of schools borrow money. And I guess at some level, if you're borrowing money, the lender has determined that you're likely to be financially responsible to do it. There's already some issues with the composite score related to refinancing debt when it happens, and it seems like it could fall into that same issue here. So just maybe I misunderstood. I don't know.
I'm sorry, is there a reference to a particular paragraph here? David?
It was a statement by
Oh,
Barmack.
by Barmack. Okay, all right.
Consider-
I'm sorry.
To consider if they borrow a lot, if there's a large new loan, that it would be potentially a trigger, but that would be a significant amount of triggers, I would think. Sorry, I was just sitting here thinking about that.
Thank you.
Okay. Thank you. Barmack?
Just wanted to quickly respond that prudential oversight does not mean you wait until people default on existing debt before you decide as a regulator to step in to say, hey, what's going on here? Prudential oversight also means that you keep an eye on the regulated entities to ensure that they don't get over leveraged. That is not there's no language. I was just suggesting that setting the triggers, if you're setting up a tripwire that far out, you're not going to catch anybody. What you're going to catch is another ITT, another Corinthian, you holding the bag. So now the proper way to deal with it would be in construction of a reasonable composite score, but that's beyond our reach. So I was merely suggesting that that if you're going to begin enumerating terrible things that should trigger a departmental review, over leveraging would be one of them before people default, not after.
And I understand the intent to catch it earlier.
Okay, thank you. All right, I'm not seeing any other hands on this section. So let's go ahead and take our temperature check on 668.171 on the entire paragraph C of that document. Jamie, I can't see your hand, your thumb. Amanda? Can I see your thumb, please? Okay, I see one thumbs down. Thank you. Brad, anything you want to add?
No, nothing extra. I'm sorry, it was Ann sideways. I thought it was down, but I was definitely down. Okay.
And
sorry.
was sideways, yeah.
I missed that, sorry.
Thank you, though, for checking. I appreciate that. It's sometimes hard to see. It's like those little Romanettes, right? All right, so Greg, you want to take us into the next paragraph, please?
Sure, I can do that. And I'm beginning to see Romanettes in my sleep, so I understand where all of you are coming from. All right, we are at discretionary triggering events. The secretary may determine that the institution is not able to meet its financial or administrative obligations under B3, Romanet 6 of this section, if any of the following events is likely to have material adverse effect on the financial condition of the institution. The first one here is it deals with accrediting agency actions, and I don't know if it was Beverly that brought this up or somebody brought it up previously. The accrediting agency actions, which are under the discretionary triggering events, so better to address that now than under the mandatory provision. So we do have that here in D1. Our proposed language changes we've changed the language here to seek here to provide more clarity about the accrediting agency actions that may trigger financial protections. So we can look at those changes. Accrediting agency actions. The institution's accrediting agency has placed the institution on probation, or issued a show cause order, or placed the institution on an accreditation status that poses an equivalent or greater risk to its accreditation. So we did make some clarifications there with respect to accrediting agency actions, and remind everybody again that we are now under the discretionary triggers. Under two creditor events, we have retitled this item what was previously violation of a loan agreement. We've retitled this item for clarity and accuracy. We have also reworked the trigger for additional clarity as to what we intend, without changing the substance of the trigger. This reflects events in which an institution or its owner is subject to a default or other condition in a financial arrangement which permits the creditor to attain certain conditions, to attach rather certain conditions to the institution. And moving down to 3, fluctuations in Title IV volume. We want to point out here again that this is a significant fluctuation between consecutive award years or a period of award years in which the amount of direct loan or Pell Grant funds or a combination of those funds by the institution that cannot be accounted for by changes in the program. So we just want to clarify here that we are concerned not only with declines, but with rapid increases as well, because of concerns about the capacity of the institution. So we have decided to elected to maintain fluctuations as opposed to just declines. Let's move to 5. Made some changes here. This is interim reporting, and we have added some language here to this trigger at the suggestion of some of the negotiators between sessions 1 and 2. So interim reporting here for an institution required to provide additional financial reporting to the department due to a failure to meet the financial responsibility standards of subpart L, or due to a change in ownership. There are negative cash flows, failure of other liquidation ratios, cash flows that significantly miss the projections submitted to the department, withdrawal rates that increase significantly, or indicators of material change in the financial condition of the institution. And if we move down to I think we have 9 state citations. At the suggestion of negotiators, we have added a discretionary trigger here to encompass significant state actions that may not rise to the level included in the mandatory triggers. This will allow the department to assess the importance of each. So you see under 9 state actions, the institution is cited by a state licensing or authorizing agency for failing to meet state agency requirements. And that is it for the discretionary triggers. So I will open it up for discussion.
Okay, thank you, Greg. Before we do the open that up, I need to make a clarification due to some questions in the chat. We are following the posted agenda as far as the order of the documents. I understand there is some mismatching of numbers, but after financial responsibility per the agenda, we will be going to certification procedures. And then from there, we'll move to change of ownership or control. So I hope that clarifies everything. I apologize for the numbers not matching up, but we will follow the posted agenda. Thanks. Jamie, you are up first on this one.
Okay, Brad's appearing on the screen ahead of me. I'll defer if you'd like.
Well, he's not on my screen ahead of you, so if you still want to defer.
Sure.
Okay.
Yep, no, that's fine. I'll accept the invitation to speak to the accreditation provision that some of my colleagues have flagged. We have a concern that hasn't been placed, and then I'll speak to the broader issue, so I don't forget the first one. The wording placed or places doesn't have a time issue. So while I don't think the department meant a 10-year-old accreditation status that has since been resolved and come into full compliance, it's odd and should perhaps be contained. I think it's probably just grammatical, but just we don't want a historic placement. It shouldn't be a discretionary trigger. That would be a waste of the department's time. More important, it does seem reasonable for the department to look at the reasons for or the possible effects of an accrediting agency action in determining whether there's a material adverse effect on the financial condition of the institution. Even though a sanction is not fine, and that's what these are. I apologize that we use different terminology, but these are all at the sanction level. Something serious is going on, and it is reasonable for the department to look into whether it suggests either news of financial fragility or concerns or trends that should be worrisome to the department that may not have been apparent to them yet, or that the effect of being in that status may, by itself or in combination with other discretionary triggers or information, be problematic. So this seems like a serious enough action by accreditors that it's appropriate to be on the discretionary list. And it's also appropriate that it's discretionary because there could be some other reasons for an accrediting action of this kind that do not affect materially the financial position of the institution, and the department would have to make that distinction. If Beverly or Kelly have other, I think those are the two, have other questions about that, I'd be happy to try and be helpful.
Thank you so much for that, Jamie. I show Kelly as next and then Brad.
Thank you. Just the number 10, the short-term borrowing, it's basically the same comment that I had raised before, where it talks about the institutions required, the line of credit or borrowing in the last quarter of the fiscal year and then replace the loan. Again, the financial statements are not quarterly financial statements. So I think you just need to think about how that would be measured.
I will take that back to our audit and accounting people and get a clarification on that.
Thank you. Okay, Brad, you are up.
Well, just since she brought up 10, I'll just piggyback on it. I mean, this is penalizing a school for repaying a line of credit. It's not tying it to a composite score here, number 10. So it's not because of end of year. So, I mean, you're saying that you can't repay the loan in the first 2 quarters of the year when you're paying interest on it. I mean, that you're giving banks free money if you're not allowing them to repay a line of credit. But back to week 1, if there's a theme for this issue paper, it really, at this section of discretionary, it really is maximum discretion to the department with no guidance to institutions. I struggle immensely with this proposal. So Greg, you help me out here. What is a high annual dropout rate?
Again, these are discretionary triggers
right.
that the department looks at for to see whether or not these are indicative of problems at the institution. It does give the department a certain amount of discretion as is pointed out with the short-term borrowing as well, but they are all here to address situations we see at institutions where it is, where the department needs discretion to determine whether or not the event rises to the level of something that we think imperils the institution's financial position, or that impairment, accrues to students. So we can obviously have disagreements about the level of discretion that the department ought to have here, but every one of these discretionary triggers addresses areas we've seen where there are problems that ultimately result in serious consequences for an institution. And it's not the department's intention to give itself undue amounts of discretion, but we also are held accountable for situations where institutions precipitously close, the effect that has on students. So we are looking at ways to identify problems in advance, and this is part of that. I mean, I'm certainly open to any suggestions people have to the language here. But I would reiterate that the department does believe it needs to have these discretionary triggers and the obvious discretion that results from them.
Hey, what about significant fluctuation? I mean, are we 90%? Are we 10%? Like, I need a little help here. I just don't get it.
Well, I mean, I don't think it would be, I'm not sure how instructive it would be to put in, 20% or 30% fluctuation. It is, again, a discretionary trigger to allow us to look at an institution that has huge fluctuations in its volume, which may be indicative of a problem at the institution. It may not be. Maybe the institution is just as expanded and has bigger programs or very popular programs that have led to many more students coming into the institution, or the institution is downsized to concentrate on a few programs that could result in lower volume as well. So it's not necessarily indicative of a problem. However, it could be indicative of a problem, and that's why it's here under a discretionary discretionary trigger.
Two discretionary equals one mandatory. We just went over that. So if I had a pharmacy school, that's a significant increase in Title IV funding. So again, I'm not following this. And then pending bar defense claims. So not actual outcomes.
Well, I want to point out that just a change in Title IV volume wouldn't in and of itself be, wouldn't be the discretionary trigger. The department would have to determine that is a discretionary trigger. So, I do want to point that out. And I get, if the point being that, I get the point that there is discretion involved here, and that there will be a divergence of opinion on how much of that discretion the department ought to be or should have. We believe that we need this level of discretion to look at possible indicators of there being trouble at an institution. And certainly we've heard the concerns about the two discretionary triggers triggering the mandatory trigger, and I'll definitely take back those concerns.
All right, and then last one on interim reporting, material change. At least the word materials there, but it's wide open to be anything, any other indicator that's material. So if you can't even define it on whether or not it's going to make it mandatory, I really struggle with it. And I've asked you on week one, and I've asked you again, and I've submitted texts proposing, but again, we've got to define some of these things. Thank you.
Thank you, Brad. And we have Amanda, Carolyn, and Beverly showing with their hands up. And then at that point, perhaps we'll be able to take the temperature check and then a quick few minutes break and pick right back up. Amanda?
Yeah, sure. Actually, I think we can hopefully, my proposal, I know it came in late, but hopefully the education department could review and potentially solve the specificity needed and in high annual dropout rates. We think the discretionary triggers research has recently shown that high annual, or actually not high annual dropout rates, but if there's low completion rates of students, that's tied to, that's correlated to, it's highly correlated to an institution's financial instability. So in our proposal, while it came in late, hopefully it suggests more specificity here. So whether the education department wants to look at it, we do suggest a change here for low completion rates, since that is backed by research as showing an indicator of it's directly related to this financial, responsibility. And we ask that if you do look at low completion rates, that would be disaggregated by Pell recipient status, by major racial and ethnic subgroups to show the different risk factors there and different completion rates. And then also we would, on the specificity of a percentage, we also do suggest, and it could be helpful here in looking at the bottom 10% of those who perform in providing the worst completion rates. So looking at those 10% of institutions who end up providing really low completion rates as a way to be more specific in this part. And then, so that's the reasoning there. I think completion rate is extremely important. We want to strive for, one, avoiding any type of financial instability, for students to, ensuring that they are completing, that they are at institutions that have the ability to support them in their education, and are not financially unstable. And then the second suggestion I'll make, and I can make this in the chat, is related to number 3, the triggering event number 3 of fluctuations in Title IV. I also know that the research that I
You have
mentioned.
30 seconds remaining.
Oh, okay, I'll just put that in the chat.
Thank you, Amanda. Appreciate it. Carolyn, you're up next.
Hi, I wanted to first say that I'm supportive of Amanda's suggestion and joined in her proposal related to the low annual completion rate language. We also would be, supportive of keeping it at high annual dropout rates, but we think that either way, whether it's looking at it from the perspective of low annual completion rates or high annual dropout rates, it would be useful to break it out, disaggregate the data as we had suggested, so that all of those subgroups, including students receiving Pell Grants, are considered. And our second part of our proposal was on the interim reporting discretionary trigger, which is a 5 here. We appreciate the department's change from the last proposal, adding the other indicators of material change, which I think is very important. But one concern we had was we wanted to make sure that it's clear that the department doesn't have to wait until after a school has already failed to have this trigger be useful. So it seems the way it's written currently is that when an institution is required to provide additional financial reporting to the department due to a failure to meet responsibility standards or due to a change of ownership. So that's very narrow. That's after they've already failed or if they had a change of ownership, but this really would be useful and is necessary to make it a little broader than that. So we suggested adding or in response to a request from the department for additional financial reporting to make it clear that the department can get additional reporting and act on it.
Thank you. Thank you very much, Carolyn. Beverly?
Yes, yes. Let me apologize for getting ahead. I had difficulty reading from the screen, and I was looking at my papers and got a little bit ahead of the accrediting agency's actions. I do agree with what Jamie said in part. Many of our HBCUs, however, are in the SAC CLC area, and there are sanctions offered, warnings, sanctions, and show cause, probation and show cause. And the institutions are given ample time to look at their status, make corrections, and report back before they lose their accreditation. And I guess my concern is how the Department of Education plans to utilize this. What's your intent? Will you be working in concert with the accrediting agencies before the withdrawal or revocation of institutions' participation in Title IV programs are affected?
Yeah, again, this, and you can certainly be forgiven for jumping ahead. I think all of us have for another tried to jump ahead. Yeah, this is a discretionary trigger. We certainly, I want to point out that this, even were this to become a mandatory trigger, we're not talking about the department necessarily entering into an action to terminate an institution as a result of it. These discretionary triggers are looking at areas that might indicate there's a problem, and I think we can it's legitimate to discuss the extent to which the department's discretion should be exercised, but I think it would have to pretty much be accepted that all of these are possible indications of a problem. And I understand with accrediting agencies that a show cause can be a number of things and perhaps not be something severe, and the school still has plenty of recourse and that type of thing. But it would be something where the department would look at it to see what the circumstance is. And we haven't defined exactly how we'll go through that process in this regulation. I think you get to the point where you just have so many regulations they would be impossible to look at. But it is something that gives us the opportunity to look at these situations and determine whether or not we feel they pose a threat to the institution's financial stability or continued existence. So we do have a very strong accreditation unit in our department that works
Know that.
with accreditors and is very good at getting to what's going on, with respect to accrediting actions, and we'd certainly utilize that. So I don't want to. This is certainly no desire on the part of the department just to simply say, oh, show cause order, therefore the school is it's got severe problems. That's not what this is meant to do. But again, it's a possible indication.
But any clarity that you could bring to the language would be very helpful.
Well, we'll take it back and see what we can, if there's something we can
Not knowing
clarify
what to
with it.
expect.
Yes, we tried to clarify it this time around, but certainly, Beverly, if you have any suggestions, please put those in the chat or get those to the facilitators, and we will consider those. Thank you.
Thank you.
Thank you. So Greg, you had walked through the entirety of paragraph D, correct?
Yes, so we could take a temperature check on that.
All right, so let's see your thumbs on 668.17 paragraph D. Okay, I see one thumb down. Brad, do you have anything additional you want to add? Okay, thanks. The public, in case you couldn't see, he was shaking his head, so appreciate that. So do you want to take a quick 5-minute break to stretch and do that, and then come back and pick right back up with paragraph E?
Sounds good.
All right, great. So I have 2:43, let's call it 2:50. Be back and we'll go from there. Okay.
Very generous.
I try. Okay, welcome back. I know it was short, but hope it was a refreshing break for you. Just a quick note before we move into paragraph E, Debbie Cochran is back at the table for state higher education executive officers in state agencies. So with that, Greg, you want to take us into paragraph E?
Right, we're moving into paragraph E. So this is recalculating the composite score. And we do note here that throughout this section, we have adjusted the language to address both institutions and their owners. And so you'll see that occurring throughout here. And just as a review about this, for recalculating composite score, the secretary recalculates the institution's most recent composite score by recognizing the actual amount of the liability or cumulative liabilities incurred by an institution under paragraph C1, Romanet 1A of this section as an expense or accounting for the actual withdrawal or cumulative withdrawals of the owner's equity under C1, Romanet 2 of this section as a reduction of equity and accounts for that expense or withdrawal. And then those are discussed here below in 1 and 2. So just again, yes, we revised that language to all the language to include to reference the institution and the owner, and also that's in 1, 2, and we've also done that in 3. So those are the only changes we've made under E, recalculating the composite score. So I'll open the floor up for any discussion on that before we move on.
Okay, great. Thank you. Negotiators, any comments on that? Okay, I'm not seeing any. Oh, there you go, Brad.
Yes, on 3, I'm assuming it's proprietary only because it's referencing withdrawal of equity as the qualifier there. But again, I'm still struggling. We went back and forth on this in last session. If you're an S corp and you're paying your IRS tax obligation, that's an equity distribution, and I do think it needs to be caveated here. I believe I submitted that comment, but could someone explain to me why we don't want to pay the IRS our bills and because it has to come through equity in order to do that for an S corp?
We're not suggesting that an institution not pay its tax liability, but here again, if we read the withdrawal of equity for the recalculation, this deals with the withdrawal of equity that's been put in for the sole purpose of meeting the financial composite score. So this is the withdrawal of equity in the entity whose financial statements were submitted for the prior fiscal year to meet the requirements of 23, or in the following year changes in ownership. The entity whose financial statements were submitted to meet the requirements of 600.20 will be adjusted by that amount. I understand that the money's that it can be withdrawn to pay for taxes, but again, our concern here is with the quite frankly the gaming situation that we discussed earlier in the mandatory triggers. But we will take back that concern.
Yeah, again, a composite score is a point in time calculation, and a tax obligation, you're paying estimated taxes in the year you're in. So you could have a 9/30 year in and pay an estimated tax obligation for the year you're in November, and that's after that fiscal year end, and that happens all the time. So I think that needs to be clarified. And I'm trying to figure out 1 and 3 why the asset for point 2 on the equity ratio is not included, because that's a big component of that ratio.
I'm sorry. What did you want to see done, Brad?
Well, it says there for the equity ratio, decreasing modified equity by that amount. Says it twice there. Trying to think about the asset side of that thing as it's a big, maybe Dave can help me out here. I'm struggling with why assets are not there. So I'll defer to Dave. He's an accountant.
If there is a situation that you want to write up, but the problem is we can certainly take a look at it. As I said before, I'm not an accountant either, so I would want to check that with our people who are.
Yeah, we could submit a consideration, just if they had an obligation, if they would have paid it prior to year end, it could have reduced the assets as part of the calculation. Also, we can submit.
Okay, thanks.
I can submit something.
Thank you.
Thank you. Seeing no other hands raised at this point, let's go ahead and take the temperature check on 668.171 paragraph E. If I could see your thumbs. Kelly, I can't decipher yours. Thank you. All right. Seeing no thumbs down, I believe is correct. Thank you. Okay, Greg, you want to take us into paragraph G? Or I'm sorry.
F.
F. Ugh.
Yeah. Trying to skip ahead, right? That's all
I'm
right.
trying to remember my alphabet.
After a while, when you forget the 1s, 2s, and 3s, J's, L's, it all just flows. One thing flows into another. Yeah. So we're looking at F here under reporting requirements. And we have made several changes throughout this section to accurately reflect that these requirements apply to both institutions and their owners. And we have made several other clarifications as well, including requiring that the updates to state, federal, and qui tam lawsuits be provided to the department, adding reporting requirements for short-term borrowing, adding a reporting requirement for institutions that are publicly listed on a foreign exchange, adding a reporting requirement for certain creditor events, and adding a requirement for the loss of eligibility for non-Title IV federal educational assistance programs, and also adding reporting requirements to align with the requirement to meet financial obligations in 668.171 B3. And here again, we've revised language to refer to both the institution and its owner. And we've also revised language to require updates to lawsuit information. So see here in F1, Romanet 2, for a lawsuit under paragraph C1, Romanet 1B of this section, not later than 10 days, these are reporting requirements again, not later than 10 days after the institution or entity is served with a complaint, and an updated notice must be provided 10 days after the suit has been pending for 120 days. In moving down to 1 Romanet 4, we have added a reporting requirement for the short-term borrowing discretionary trigger that we added. So if we look at Romanet 4, for a contribution and distribution under paragraph C1, Romanet 10, and the short-term borrowing provision in paragraph D6, not later than 10 days following each transaction. And moving on to 5, we have revised this language to refer both to institution and its owner. In the interest of brevity, we have struck out the language that repeats what was in the trigger and instead added a reference to that section. So you can see there that language has been stricken, and we now say for the provisions related to a publicly traded entity under paragraph C1, Romanet 6 of this section, no later than 10 days after the date the event described under paragraph C1, Romanet 6 occurs. And moving down to Romanet 6, this is just updating the cross sections here. for the actions, and you can see so. Under Romanet 7, we have added a reporting requirement for the mandatory trigger related to the creditor events. So for creditor events described in C, Romanet 11, not later than 10 days after the date on which the institution is notified by its accreditor. And under 8, Romanet 8, we've updated the header for the creditor and events discretionary trigger and updated the timing for the reporting requirement, as well as added needed updates. So there, that's under 8 for the events described in paragraph D2 of the section, not later than 10 days after the event occurs, with an update not later than 10 days after the creditor waives the violation or the creditor imposes sanction or penalties, including sanctions or penalties imposed in exchange or as a result of granting the waiver. In Romanet 10, we have added this reporting requirement to refer to federal educational assistance funds, since the 90-10 rule will no longer be limited to Title IV funds, and you can just see Title IV revenue replaced with federal educational assistance funds. And for, yeah, that's fine. Okay, I want to go down to 12. We have added this reporting requirement to address the requirements to meet financial obligations under 668-171B. So for a failure to meet any of the standards in paragraph B of this section, not later than 10 days after the institution ceases to meet the standards. And moving on to here we mistakenly failed to remove this language under A. We mistakenly failed to remove this language in the first session as intended. It would otherwise allow institutional owners to withdraw equity for the purpose of meeting tax liabilities, which we did not intend to exclude from the trigger. And that is everything for reporting under F. So open that up for comment.
Okay, thank you. Vanessa, thank you, Vanessa. I appreciate it. Open it up to the negotiators for comments or questions. Brad?
So removing of A under I, or Romanet 1, I guess, the tax piece that you just mentioned. Can you say again, why is that being removed? Is it saying you don't want to know that? Help me. Or did you say it was mistakenly removed, or? Sorry, I'm not following that.
No, here we mistakenly failed to remove this language from the first session. We mistakenly failed to remove this language in the first session as intended. It would otherwise allow institutional owners to withdraw the equity for the purpose of meeting tax liabilities, which we did not intend to exclude from the trigger. So this would just be removing the.
Sorry.
Right. Well, this is just the. Remember, this is under the.
This is
in this section the. We're just stating here that we're not indicating that an institution could do that.
So again, we don't have to notify, or we do? I'm sorry. It reads so funny to me. does the department want to know that we're paying our taxes? That's what I'm trying to figure out, Greg. I'm sorry. It just doesn't.
No, in this case, that's been removed. This requirement's been removed because we didn't intend for it to be a something that would excuse an institution from the trigger.
Okay, thank you.
So let me try to clarify that as well.
Sorry,
Let me clarify Greg's clarification. The notice still has to be provided to the department, but the institution can no longer present information showing that the withdrawal that triggered the notice was because the funds were used to pay taxes.
I'm more confused.
I know, I understand.
So does the department want to know that we paid taxes? Do we have to notify them? That's what I'm trying to determine here.
It's the withdrawal of the funds that triggers the notice. Right, that's the reference.
Which is not mitigated by the need to pay taxes.
I'm trying to think of another way to say it. I'm still not clear. I'm sorry. Do we have to notify the department if we withdraw money as an S corp through equity to pay our taxes?
If the withdrawal is caught within this timing structure of being money taken out after equity was put in within the time frames in the regulation, you have to provide notice, even if that withdrawal was used to pay taxes.
And remind me of the notice time frame again. It's buried in 2. What's the time frame? I'm sorry.
Yeah.
Let me go back and look.
I'm really just trying to understand the rule.
$10 days.
Thank you.
10 days.
So within 10 days of the fiscal year, and we have to notify you. Anything outside of that, we don't.
Well, not the triggering. No, the triggering requirement goes from into the first. Was it Steve? The first quarter of the next year.
Yeah, it's the equity put into the institution within the last quarter that's withdrawn within the following 2 quarters after the change in the fiscal year.
And when that happens, you have 10 days to notify us.
Even if it's to pay taxes.
Correct.
Yes, even if it's to pay taxes, that's why that was taken out.
Okay. I don't understand why that's in there, but it's the same comment I guess I had earlier. So thank you.
Thank you, Brad. Kelly, you're next, and thank you very much for your 10-day visual, and Barmack for your audio piece of that. Appreciate it. Kelly, go ahead.
Yeah, I suppose I could have just come off of mute. Anyways, in F3, I would just like the department to consider the language that I sent over for the next round. I know I was late, but my other job kind of got in the way. I apologize.
Okay. Thank you, Kelly. Barmack?
Yeah, I'm still struggling with Brad's concern about the taxes. I think the department is interested in whether the institution is losing money, is withdrawing funds. Whether to buy a yacht or to pay taxes is really not relevant. At the end of the day, the department's interest is in the soundness of the institution, of the entity. So acting as if it's just the payment of taxes that's causing a concern is sort of like privileging one particularly noteworthy and laudable thing, as if the department is stopping the payment of taxes. It's just the issue is, are you withdrawing funds to the point that the institution begins to become destabilized?
Okay. I think the department needs some time to digest and react to that. If that's okay.
I will say, I mean, again, this goes back to our concerns over an institution contributing equity and then withdrawing it right away. So that because we have seen instances where that is done clearly to help an institution meet composite score requirements, and then that money is withdrawn. So it doesn't it's not indicative of anything other than that. And of course, yes, an institution could withdraw money for any number of purposes, and taxes are one of those, but it doesn't change the fact that that the event occurred and that it could indicate an institution's desire to try to manipulate the composite score.
Thank you, Greg. Brad?
Just to respond to that, I completely understand the manipulation of the composite score piece, and I understand why that's of concern. I do struggle with the way equity works, in the fact that, certain months of the year may be more income, certain months of the year you may have a loss, and how that all flows through equity, and then you've got to pay taxes. And I disagree with Barmack's comment. There is a difference if you're taking out equity to buy a yacht versus paying the IRS. And S corps have significant amount of distributions to pay taxes. That is where the federal taxes are paid. So they're not paid through the bottom line of the school. They're paid through the owner's personal income statement. And that's the way an S corp works. And so I think that's got to be figured out. Maybe that's the difference. Maybe you put an exclusion for S corps and you leave C corps as is. But
Okay. Okay. Seeing no further hands, let's go ahead and take a temperature check on 668.176 paragraph F, reporting requirements. Sam, I can't see your thumb. There you go. Thank you. Okay, I'm seeing Ernest. Okay, I'm seeing one thumb down, unless someone sees anything else. Kelly, is there anything else you want to add?
No, I would just like them to look at that proposed language so that we can discuss it.
Okay, thank you.
We'll do that.
All right, Greg, let's move on to G now. Okay, I think I got my alphabet straightened out.
I think we're good to go. Yeah, G. We're at public institutions, and looking at specifically here G1, Romanet 1 B. We've updated language to mirror what we require for foreign institutions, and align it with the requirements in new 668-176 for public institutions. So here you can see Secretary considers a domestic public institution to be financially responsible if the institution notifies the Secretary is a designated public institution by the state, local, or municipal government entity, tribal authority, or other government entity, and has legal authority to make that determination, and provides a letter from the official or the state or government entity confirming that the institution is a public institution and is backed by the full faith and credit of the state, local, or municipal government entity, tribal authority, or other government entity. Moving on to, and that is everything actually for H. So that's very brief.
That would be A. Yeah, that would be G. Everything.
So you know what? Let me just take. I'm sorry, for G rather. So let me just take G and we'll do H and do G and H together, and that way we'll be at the end of the. We'll be at the end of 173.
Okay.
So let's move on to where we also have made some changes to H, and we note that we have made these edits to further clarify how the department may agree to treat auditor opinions, including if the auditor believes that the concern has been alleviated. So you can see that those changes reflected reflected there. Even if an institution satisfies all the general standards of financial responsibility under paragraph B of this section, the secretary does not consider the institution to be financially responsible if the institution's audited financial statements, opinion expressed by the auditor that was adverse, qualified, or disclaimed, or includes a disclosure about the institution's ability to continue operating or its ability to continue as a going concern, unless the secretary determines that a qualified or disclaimed opinion does not have a significant bearing on the institution's financial condition, or that the diminished liquidity, ability to continue operations, or ability to continue as a going concern has been alleviated. The secretary may conclude that diminished liquidity, ability to continue operations, or ability to continue as a going concern has not been alleviated, even if the auditor states those concerns have been alleviated. So those are the changes for both G and H. Open that up for discussion.
Okay, thank you, Greg. All right, open it up to the negotiators. Barmack?
To go back to G, you know, we are attempting to write regulations that may stay in place for decades. And we should be smart enough to kind of anticipate where the next wave of waste, fraud, and abuse may pop up. We have historically had the assurance that the public sector has been beyond reproach when it comes to outright fraud. I humbly suggest, and this is not intended or targeting anybody participating in this on behalf of public institutions, it is just the concern I have with sort of leading indicators of problems down the road with some publics. So it seems to me that failing to address what is a public institution beyond the sort of a historical remnant may prove quite problematic. It seems to me that we are already, and I won't name names, but we have already seen examples of public institutions attempting to stand up proto-publics, hiding behind the fact that the parent entity is a brand name, while offering nothing but fairly abusive predatory products. So I would really urge the department to go back and think this through. This may be our last bite of the apple before 20 years. We need to focus on what being a public institution really means in terms of governance, in terms of conformity with state sunshine laws. It is insufficient to allow this just the board of directors of one public institution to dub another entity public by fiat. So, and I submitted some language to that effect, but I really want to urge the department to go about. I don't need a response here, but I want to tell you, if you don't do something with this here, be prepared to see a rip-off global campus attached to every marquee name in public higher education in this country. Publics are under duress. They're being privatized. They are being disinvested from, and consequently, they're out there looking for funding. And sadly, a few of them have discovered that the only way they can balance the books is by running a predatory side business from the proceeds of which they then subsidize their traditional students. So it's a real problem. I hope the department takes it seriously.
Thank you.
Thank you, Barmack. Debbie?
Thank you. My comment was actually on the same clause with a specific suggestion to add a requirement that the institution be subject to the same financial oversight and public records laws as in the state or local government where the institution is based. So I'll put the language in the chat.
Thank you.
Thank you. Okay, I'm not seeing any other hands, so let's go ahead and go with the temperature check on paragraphs G and H. You want those separate, Greg, or both together?
Combined is fine.
Okay, all right.
Could you put them back up on the screen?
Well, then I have difficulty seeing seeing the actual thumbs. If we
Could
do
we
that.
see it for a second before we do the temperature check?
Sure.
Go ahead, Vanessa, throw it back up. She can, I don't think she can show G and H at the same time, but she can scroll
Right.
to G and then scroll down to H. Normally, I don't like to put them together, but in the interest of time and getting to the next
Yeah,
section.
sorry to hold you up.
Oh, that's okay.
Thank you, at least for me.
Okay, thank you, Jamie. Vanessa, if you could take that down, please. Thanks. If we could see the thumbs, I'd appreciate it. Okay, I'm not seeing any thumbs down. Thank you. We have approximately 9 minutes before public comment. So Greg, do you want to move right into the next section? And at least get it started?
Yes, so this is pretty brief. We are going into 174, which is past performance. And Vanessa has that up. Thank you, Vanessa. And we're looking at not many changes here. We've simply corrected a cross-reference in here in A. I'm sorry, no, not in A. We corrected cross-reference in B2, B2 Romanet I. So that's what we did in B. And then moving down to C, ownership interest. For simplicity, we have eliminated this definition and cross-referenced it and cross-referenced to 600.30, 600.31. And that is in ownership interest C. And that is, if you just, and so the way that reads, I should go over that again just for clarity. You have ownership interests, and ownership interest is, instead of all that text, defined in 600.30 and 600.31B. And that is it for 174.
Thank you. So we can open it up for discussion. Any comments or questions? Okay, not seeing any. Let's go ahead and do a temperature check on 668.174 past performance. All right, no thumbs down. Thank you. Greg, back to you. Something happened to Greg?
Hey, Greg, you're muted, I believe.
I'm very sorry.
There you are.
Mistake. So I think in the time we have left, we've got, looks to be like 6 minutes. We can try to address 175 here. There aren't many changes. And then we'll be ready for 176, which we'll definitely have to take up tomorrow. So in 175, if you'll go to 175C, we've made some minor edits here to address misalignment that negotiators had noted between this language and the updated language in the audit opinions section of the rule. We've also made another update to include going concern, consistent with the edits that we made above. And in this paper and in the other papers where we refer to surety, we have now changed that language to use the broader term financial protection. So you see that referenced here in C. Participating institution that is not financially responsible either because it does not satisfy one or more of the standards of financial responsibility in 668, 171B, C, or D, or because of an audit opinion or disclosure about the institution's liquidity, ability to continue operations, or ability to continue as a going concern. And then below that, you see that we have changed surety to financial protection. And that, I believe, is want to go over to, I'm sorry, we want to go over to In D, which is the zone alternative, I'm sorry, no, E, F. And if we go over into F, under F2, this is provide the secretary with a revocable letter of credit. We are still considering whether this is a manageable standard, but are concerned that the department will struggle to confirm what amount would ensure it is held harmless, and we welcome any feedback as to whether another amount makes sense. And we note that Ed retains the ability to require a larger letter of credit than 10% if we deem that as necessary. So that was just in reference to the 10% letter of credit requirements, and that is it for 175. So we only have a few minutes left, but maybe we can take a comment or two before public comments.
Brad, I'm sorry, Brad, go ahead.
Yeah, I put it in the chat, but I would like to add the words, and I propose to take reasonable steps to both C and F2, and so you'll have that language in the chat. Thank you.
Thank you. Ernest?
Yeah, I just wanted to make a quick note before public comment. Obviously the past couple of days of this session negotiated rulemaking have been extremely technical, particularly some of the discussions around financial responsibility. I want to zoom out for just a moment, encourage the committee to center students and kind of remind the committee that places, institutions like Corinthian and ITT Tech that have closed have done lasting harm to hundreds of thousands of people. A new report by the Project on Predatory Student Lending came out today that actually highlights some of the misdeeds that happened to ITT in particular that I think are pertinent to the committee. But I'd be happy to share those in the chat. But for me, just kind of refreshes the need for these conversations, our discussions, but also strong regulation. So I just want to applaud the direction that both this regulation and financial responsibility and gainful employment are kind of moving in, which of course is that of protecting students. Just wanted to say that for public comment.
Thank you.
Okay. Thank you. Kelly?
So my comment is general to financial responsibility. This seems like the right section to talk about it real quickly. And I don't have proposed language, but I'd like the department to consider a couple of things. Based on the fact that we're not opening the composite score calculation and the fact that we know that there's potential issues with it, and the fact that there's no appeal process to it, there's private nonprofits in the financial statements. There's a new footnote disclosure, which is meant to show available resources. And that footnote disclosure will show the resources that the institution has on hand in order to continue operations and such. So as I think about schools in the zone alternative, if they ended up there potentially by mistake because of an error in calculation, or because the calculation isn't really showing that they're going to close, that maybe that liquidity disclosure or available resources disclosure could be used by the department to look at whether or not that institution is financially responsible. It's an audited footnote by auditors, and it does give some insight into where the institution is financially, as far as being able to pay its bills and whether or not it's going to be able to continue operations. Just a thought.
Thank you.
Thank you, Kelly. Seeing no additional hands, let's go ahead and move into the temperature check on 668-175 alternative standards and requirements, and then we will move directly to public comment. Barmack, do you have a quick comment? You're on mute.
I don't know that we can address this. I put this in the chat, but I would like to have a conversation about this. I submitted a memo for the record that questions the department's statutory authority to configure the sureties it demands by tying it to Title IV volume as opposed to total institutional liabilities. I think that's a big deal. I don't know that we can really sidestep the issue. I'd like to hear from the department some kind of a response.
Can't do that today, but I'll see if we can address that tomorrow.
Okay, Carolyn?
Yes, I think that I just wanted to add on to Barmack's comment. I think that his comment is relevant to this section, which talks about the 10% figure for Title IV, and I support his suggestion, not just in the context of whether or not the department has a statutory requirement to do things differently, which is one question, but also even if that were not the case, that just to suggest that it would be a good idea for a letter of credit to consider the total liabilities that the school could owe, as opposed to just looking at the previous year's Title IV.
All right, thank you for that. I think now that we are past the time for public comment, I think, Greg, if you're okay, we'll defer this temperature check till first thing in the morning.
That's fine.
Okay, all right, thank you. Brady, can you tell me who's up first for public comment?
Yes, ma'am. I just admitted Laura Rao, who is here representing themselves.
Okay, thank you. Hi, Laura, can you hear me?
Yes, I can.
Wonderful. You have 3 minutes to speak, and that time will start whenever you're ready.
Thank you very much. I'm ready.
Okay, go ahead.
It's nice to meet you. Thank you very much for listening to me today. My name is Laura Rao. I have an MBA from the University of Phoenix. It was the second MBA program I started. I started with Chapman College right out of my undergrad bachelor's with econ. I wanted to speak about the University of Phoenix very flexible program. I attended at night and studied on weekends. The MBA allowed me to get the controller job I was searching for to get the salary I needed. I had one small child at home. My husband and I both attended their MBA program, and it allowed us to make the career changes that we wanted. As a result, I worked 30 years in finance as a leader, controller, and CFO, executive positions, and now I help people start businesses. Having attended 2 MBA programs, I feel like gives me kind of a unique point of view. The education that I received at University of Phoenix was more real life, pragmatic, and flexible, and it allowed for me to manage my family. It was tough, but I made it. So I believe a quality education is one that helps people be more successful and effective at work. And for that, the University of Phoenix MBA program did it for me. If you have any questions, I'd be happy to answer them. I would just like to thank you for listening.
We thank you for that, Laura. We appreciate your time and comments. Brady, who do we have next?
Okay, I am admitting Mr. Jeff Weiss, who's here representing himself.
Okay, thank you. Good afternoon, Jeff. How are you?
I'm doing well, thank you.
Wonderful. You will have 3 minutes to present your comment before the committee, and your time will start when you begin to speak. Thank you.
Perfect. Thank you for the opportunity to speak with you all today. My name is Jeff Weiss, and I'd like to share my experience attending college as a working adult. I've tried both brick and mortar and online schooling options, but I can say that I needed what some would call a non-traditional school program in order to complete my college degree and ultimately further my career. When I entered the workforce in 1996, I knew that I would eventually need a degree to further my career. I got to the point where I finally had the financial freedom to pursue a degree, but I could not quit my job to go to school full-time or attend classes in person. My work hours were very erratic, and there weren't many college options for me. Luckily, I knew of the University of Phoenix from a friend and the options that they had for people with busy schedules like mine. I was able to enroll there, complete one course every 5 weeks, and earn my degree on my own time. I had the opportunity to work with people from all over the world and experience a richly diverse learning group, which was very important to me. I believe that this gave me a great advantage in my career as a human resources professional. I know that you're discussing how to measure a good return on investment for those pursuing a degree, and I hope you consider what that means for working adults. If it weren't for the University of Phoenix programs, I don't know that I'd have a degree today or how it would have affected my ultimate career choices. Not only did I get to work and gain experience while completing my degree, but I also learned the business skills needed to advance my career after graduating. My experience at Phoenix means a great deal to me, and I would call a career-focused and quality program. Please consider my story and take care that you do not limit the options for adult students who pursue career-focused programs. Thank you.
Thank you, Jeff. Appreciate it. Brady, who do we have next?
Cindy, I just admitted Dawn Tremiglio, who is here representing themselves.
Hi, Dawn. Can you hear me? Dawn?
They turned away from their computer, haven't enabled their audio. Do you want me to message them and let in the next speaker?
Yes, please.
All right. I have just admitted Robert White, who is the Corporate Medical Director of PIH Medical.
Is he on camera? Mr. White, can you hear me? Here he comes.
He was just able to, there you go.
There he is. Okay. All right, Mr. White, you have 3 minutes. Thank you for joining us. 3 minutes to speak today. And that
Thank
time
you so much.
That time begins when you're ready to start speaking. Thank you.
Can you all hear me okay?
Yes, we can. Appreciate
Fantastic.
it.
My name is Robert White. I'm a physician assistant, as well as a retired Army flight surgeon from Knoxville, Tennessee. In 2017, I was given the opportunity to apply for the physician assistant program at South College in Knoxville, and I was accepted into South College's inaugural class, 2009. While I was in the program, I was elected as the class president, and I worked very closely with South College PA staff, and I also had the dean of the program as my personal mentor. Over my military career, I've had 4 conflict deployments that ranged from Somalia in 1993 to Taji, Iraq in 2011-2012, where I helped lead a traumatic center and was the assistant brigade flight surgeon and the battalion surgeon. After 23 years of combined military service, I finished my military career and retired as a captain flight surgeon in the 63rd Aviation Brigade. In my civilian career, I've worked in emergency medicine, family medicine, pediatrics, occupational medicine, geriatric psychiatry, and I'm also currently the corporate medical director for a nationwide heavy civil construction company headquartered in Knoxville, Tennessee. I'm also the owner of a CEO of a rural healthcare practice that cares for individuals and families that cannot afford healthcare insurance. I've been on the board of the member of Tennessee Academy of Physician Assistants, still very active in the Government Affairs Committee. Last year, I was appointed by Governor Lee to the Board of Physician Assistants, and I've been appointed to the Controlled Substance Monitoring Database Committee as well for Tennessee. As you can see, I've worked very hard to be of service to my country, my state, my profession, and to my community. In saying that, South College has given me the education and training to practice medicine at the top of my abilities in the scope of my practice, as well as encouraging me to be an advocate for the physician assistant profession and to help me to understand how to be a lifelong learner and a generous contributor to my community. I can say without a doubt that South College has forever changed my life and allowed myself and my family to have opportunities that I would have never been able to have without being accepted into the South College PA program. I want to thank you all for your time and thank you for hearing my testimony.
Thank you, Robert. We appreciate it. Dawn, if you want to go ahead and unmute yourself.
Okay.
Okay. Hi, welcome, Dawn. You have 3 minutes to address the committee with your comments, and your time will begin when you're ready to speak.
Okay, thank you. Hi, everyone. My name is Dawn Tremalio. Thank you for allowing me the time to speak publicly to the Department of Education, who is setting the rulemaking process to ensure transparency across all higher education. I'm here to share my story. I understand that you're deciding on how to determine if a degree program is a good investment, and I believe that there are many factors contributing to this. In my case, flexibility was the key. I am a two-time graduate from the University of Phoenix with an associate's degree and a bachelor's degree. When I first enrolled, I did not care about the tax status of the university. I simply knew that I wanted a complete education on my own schedule, and University of Phoenix allowed me to do that. As a full-time IT consultant for Nationwide Insurance, I need a flexible program, and I was thrilled when my company even helped me pay for my college education. However, it took me many years to complete my degree program because I had to fit the work into my professional work schedule, and I was also working through some health issues at the time in my personal life. I was grateful that the flexible and quality program at Phoenix enabled me to eventually graduate with my bachelor's degree, which would not have been possible at a public university. Today, I ask that you please consider how you measure the degree programs and whether that be through new gainful employment rules or otherwise. And I ask that you do not proceed with bias. It's unfair to target specific schools or institutions because of their tax status when they offer quality and flexibility to accommodate schedules for students. Please use your broad authority to apply the rules and regulations to all institutions with the same fervor and standards. And please continue to work to protect and prioritize education for working adults, such as me. Thank you for your time today. I appreciate it.
Hey, thank you, Don. Brady, who is next?
Cindy, I am now admitting Lisa Giordano, who is here representing the Association of Young Americans.
Hi, Lisa, can you hear me?
Yep, can you hear me all right?
Yes, we can. You have 3 minutes to address the committee, and that will begin whenever you're ready to start speaking.
Great, thank you. Hi all, thank you for having me here today. My name is Lisa Giordano. I'm the Executive Director of the Association of Young Americans, also known as AYA. We are a nonprofit, nonpartisan membership organization representing over 23,000 young people across all 50 states. We advocate on behalf of our membership at the federal level on the issues most important to them. Among the most critical is student debt and higher education reform. So again, thanks for having me here today. I am honored and grateful for the opportunity to speak on behalf of AYA's members, about 70% of which are student debt holders, and some of which have attended for-profit institutions, higher education institutions. Many members have shared with me their largely adverse experiences with these for-profit institutions, and I'd like to share some of those with you all now, and also to speak on the importance of the gainful employment rule and the importance of reinstating this rule to protect students and borrowers. So the story that stuck out to me more than any other among our members is from a member located in Boulder, Colorado, who currently has over $400,000 in student loans to his name. He was defrauded by a for-profit law school that lost its accreditation from the American Bar Association. So we all know the value of a law degree and how much debt people go into to pursue a career in law, expecting to be high earners after graduation. This member was obviously operating under the same assumption, only to be left with hundreds of thousands of dollars in debt for a degree that didn't work. No institution should get to the point of losing its accreditation. The Department of Education should have accountability measures and standards in place to make sure institutions are delivering to their students, especially these high-cost institutions with promising high-earning degrees. So reinstating the gainful employment rule is critical in ensuring these situations don't present themselves. The department can successfully protect students from taking on debts they're unlikely to be able to repay, and ensure that career programs are able to better prepare students for gainful employment following graduation. Another story from another member that attended a for-profit institution. This member is in Sunnyvale, California. After the first few years of paying her debt off, she owed more than she did at the beginning due to low wages in her new job and high interest on her loans. A direct quote, "It made me feel like college was the dumbest decision I've ever made." I think we can all agree that no one should feel that way upon dishing out thousands, sometimes hundreds of thousands to pay for a college degree. This should be one of the best investments we make, yet many—
There's 30 seconds remaining.
Oh, I'm sorry. I'm going to just skip to the end. Young people have borne the brunt of the student debt crisis, and we've had our voices largely silenced and hardship unrecognized as we struggle with our debt loads and dysfunctional degrees. For-profit students have had it the worst. We know that students at for-profit schools are less likely to graduate, more likely to borrow, are deeper in debt, and less able to pay off their debt. And so again, reinstating the gainful employment rule is a critical opportunity the department has to successfully protect students from taking on debts they're unlikely to be able to repay and ensure that we're able to find gainful employment after graduation. Thank you very much for having me.
Thank you, Lisa. Brady, who's next?
Cindy, I'm admitting Carrie Kennedy, who's the Institute Director of the Institute of Beauty and Wellness.
Hi, Carrie, can you hear me? You are on, you need to unmute yourself, please. Thank you.
Hi.
Hi, great. Carrie, you have 3 minutes to address the committee today, and that 3 minutes will start whenever you're ready to begin speaking.
All right, thank you. Good afternoon. My name is Carrie Kennedy, and I'm the director of the Institute of Beauty and Wellness located in Milwaukee, Wisconsin. I'm also representing our sister school, Aveda Institute Madison. Our school provides education in the fields of cosmetology, barbering, osteology, massage therapy, and manicuring. Cosmetology schools are a unique subset of Title IV participating schools, and unfortunately, cosmetology schools do not have meaningful representation in these negotiations. This is reflected in the conversation during the first session. For this reason, I feel compelled to provide public comment and provide some context to our schools and our programs. First, I would like to invite each of you to come and visit our schools and learn about our programs, our students, and our graduates. There is truly no substitute for learning about our schools and programs than firsthand. Most of our students are women and nearly half are Pell eligible. Our graduation rate at our Milwaukee campus is a 79% and at 83% at our Madison campus. Our median loan debt for both campuses is approximately $6,333. Our graduates' monthly payments are approximately $63 a month. I share your concern about high student debt and debilitating loan payments, but it'd be hard to argue that payments of $63 a month are debilitating. Our median earned for both campuses is $34,885. Despite these successful outcomes, the regulations you're writing would force schools like mine to close programs. It is well recognized that cosmetology industry has a high prevalence of underreported and unreported income, which results in inaccurate earnings data from cosmetology graduates. As drafted, the gainful employment rule fails to adequately account for earnings of cosmetology school graduates. I would propose 3 simple solutions. Consider utilizing the alternative earnings data source for programs in certain CIP codes. Create a mechanism within earning calculation that allows plus up on reported earnings to adequately capture underreporting. The Department of Education is armed with the 2014 GE survey and could provide an appropriate algorithm. And reinstate the appeals process to allow institutions the opportunity to correct inaccurate earnings. In drafting this rule, I would ask you to think about our students, particularly our students at my school.
You have 30 seconds remaining.
Alexia, who is from our 2008 osteology graduate, who has returned to take a cosmetology program in 2021, so she can work alongside her licensed barber, that is her husband. Their passion is to provide education in the community. Or Brady, who graduated in January, who helped to start a new service at our salon, specializing in supporting beauty needs for transitioning guests. These students are the core of our mission, and I hope that you'll recognize their faces and their stories when you discuss gainful employment. Thank you for your time.
Thank you, Carrie.
Thank
and the
you.
3 minutes goes fast, I know. Thank you.
All right, thanks, guys.
Brady, who is next?
Cindy, I just admitted John Roberts, who is a veteran representing themselves. It looks like they're in the meeting. They just got to enable audio.
Waiting on his audio to connect. Looks like there's some difficulty there, Brady. While you try to help him, do you want to admit someone else?
Sure, I'll admit Neil Heller, who is here representing the Hollywood Institute and Cortiva Institute.
Good afternoon, Neil. How are you?
Good, how are you?
Wonderful. You have 3 minutes to address the committee today with your comments, and that 3
Okay.
minutes will start whenever you're ready to start talking.
Okay, let's go.
Okay.
Good afternoon, everybody. My name is Neil Heller. I'm the Government Relations Chair and a member of the Board of Directors for the American Association of Cosmetology Schools, representing over 600 beauty schools across the country. I'm also a school owner. As a former negotiator in the last round of negotiated rulemaking, it's especially disappointing that the Department of Education failed to understand the importance and relevance to these proceedings to have a representative from our sector of higher education. Our schools offer non-degree granting programs for state licensure in cosmetology and other beauty, health, and wellness-related career fields. We do not offer degree granting programs. We are not them. The rules this panel is discussing are particularly relevant to our schools and, more importantly, our students. The gainful employment rule is directly related to the misconception that our graduates incur high debt with little career opportunity. This couldn't be further from the truth. Over 90% of those working in the multi-billion-dollar beauty industry are graduates of our schools. Graduation and placement rates far exceed those of community colleges that offer the same programs. Our grads have less than $10,000 of student loan debt, roughly $1,000 per year in repayment. We are not the reason for today's student debt crisis. That responsibility belongs with traditional colleges and universities. An in-depth, extensive analysis by the Wall Street Journal clearly demonstrates this. Underreported or unreported income is a real issue for our schools as it pertains to gainful employment. To say anything else is simply a false narrative. A U.S. District Court clearly stated in a lawsuit brought by our association that the earnings data used by the department in the 2014 version of gainful employment was flawed. The judge called the appeals process arbitrary and capricious and ordered the department to fix it. The department, in its own words in the 2014 rule, acknowledged that there was specifically an earnings problem in the cosmetology industry. Apparently, this problem's answer to the district court is to continue down the same path as the 2014 rule and go even further by eliminating the appeals process altogether. We can't wait to hear Judge Contreras' reaction to this incredible position. Although the 90-10 rule has been resolved on a bipartisan basis in Congress, this panel wants to supersede Congress's agreement by further defining federal aid. Although every single state has its own hours requirement for licensure, this panel is discussing a cap on federal aid for cosmetology students, which would result in disenfranchising tens of thousands of students from pursuing their chosen career path.
You have 30 seconds remaining.
I would love to go deeper into these and the other subjects being discussed over the course of these sessions. However, I have been limited to a paltry 3 minutes to address these critical areas of concern. If the expertise needed to be part of these discussions had been allowed in the first place, an effective outcome and consensus might have prevailed. Or perhaps that was the plan all along. Thank you.
Thank you very much, Neil.
All right, thank you.
Brady, who's next?
We have John in the chat right now. John, if you just want to come off of mute, I think we're
Yep.
ready to go.
Thank you.
Okay.
Hi, John.
Hi, how are you?
Good. You have 3 minutes to address the committee this afternoon, and that starts whenever you're ready to start talking.
Thank you for having me. Good afternoon. My name is John Roberts, and I am an Army veteran. I was trained to fly helicopters in the Army, and when I retired, I wanted to earn my certification to fly airplanes. Liberty University was the only school that offered a program covered by the GI Bill specifically geared towards transitioning students from flying helicopters to airplanes. The program seemed perfect for me, but it turned out to be too good to be true. Liberty recruiters promised me the program to lure me to their school. But when I registered for courses, the flight program was no longer available. I first learned about Liberty's Rotary Wing Transition Program in 2020. Liberty seemed to be marketing it specifically toward military personnel. At that time, the landing page, the welcome page, featured photos of Black Hawk helicopter and Army helicopter pilots surrounding it. I didn't enroll them, but in late 2021, Liberty directed its flight training affiliates to reach out to formerly interested students like myself. I was contacted about applying for that training program. I received frequent texts and calls, and I always firmly stated that I would not attend Liberty unless I was enrolled in the flight training program. I applied and was accepted to that program. However, when I was trying to complete the registration online, I encountered an issue. I registered for my 3 semester hour credit aviation course, as well as 7 credits of online coursework in other topics such as Bible study in order to fulfill Liberty's degree requirements. When I went through the financial check-in for that registration process, I was charged for all 10 credits. Everything seemed to be up and up. But when I clicked to confirm everything, the next page showed that I was only registered for 7 credits and no flight training. After unsuccessfully seeking help, I withdrew from the other courses because I had no interest in taking general education courses at Liberty. I already have a bachelor's degree. I went to Liberty specifically for this transitional flight training program. Because of my age, I only have a few years before, in order to work in a commercial aviation industry, the only thing I'll be able to do is teach.
You have 30 seconds remaining.
Thank you. And Liberty was wasting my time. In addition, I incurred expenses in reliance on my acceptance to Liberty's flight training program, including buying an iPad, materials to complete an initial check ride, and reserving hotels for my flight training, which would take place a few hours away from home. I feel that Liberty marketed its program to veterans with a promise of a tailor-made program before pulling a bait and switch. I am here today to ask the Department of Education to continue to regulate schools like Liberty that are recruiting veterans and failing to fulfill their promises. Schools should not be allowed to entice us to enroll with the promise of a program and then fail to offer that program while keeping us enrolled and charging.
Your time at 3 minutes is completed.
Thank you. Thank you for hearing me.
Thank you very much, John. Brady, we have time for one more.
I'm admitting our final speaker, Sandra Bruce, who's here representing Milady, where they are the Vice President and General Manager.
Okay. Is she off? There she comes. Hi, Sandra. Can you hear me?
Hello, Cindy. Hi, how are you?
I'm wonderful. And yourself?
Good, thank you.
Okay. Sandra, you will have 3 minutes to address the committee this afternoon, and that 3 minutes will start whenever you begin to speak.
Okay, very good. And is that happening now or what time?
Yep,
Okay.
no, right now. Yep, you're
Okay.
good to go.
Very good, thank you.
Yep.
Thank you for allowing me the opportunity to speak today. I am Sandra Bruce, Senior Vice President at Cengage Group and General Manager of its Milady business. I've been with Cengage for more than 26 years. Cengage is the largest US-based education publisher with 100 years experience serving learners from kindergarten through higher education. Milady is a beauty education provider with 95 years of creating content for learners pursuing occupations in the beauty industry. As a participant in the higher education landscape, we are keenly interested in promoting strong student results and strong student outcomes. Our mission is to drive career success by inspiring the pursuit of knowledge through innovative solutions. Since 1927, we have worked to meet the needs of learners, educators, and employers by developing coursework that maintains pace with industry changes. We pride ourselves on providing students cutting-edge resources. Today, there are more than 185,000 learners a year using Milady textbooks or digital courseware. Those learners are educated in high schools, in VOTEX, community colleges, correctional facilities, career colleges, and for-profit beauty schools. Students pursuing careers in beauty occupations have a rigorous curriculum, including anatomy and physiology, chemistry, electricity, financial literacy, as well as practical training for procedures related to their field of specialty. They learn professionalism and communication skills as the foundation for a successful career. Most students pursuing a career in the health and beauty industry, in fact, nearly 2/3 of students do so at a for-profit beauty school. The vast majority of these beauty schools are small businesses with an average of 25 to 50 students a year. They are accredited, state authorized, and approved by the Department of Education to offer Title IV. The average student in a beauty-related program is a creative and not typically a traditional learner. 38% of the students are under 25 years old. 73% are under 35 years old. These students are seeking a focused education that will lead them to the marketplace with lifelong skills in a career they love. Student outcomes for graduation, licensure, and job placement are not only state mandated, as beauty schools must be licensed to operate in their state. They are also mandated by accrediting bodies for the school to qualify to offer Title IV funding to prospective students.
You have 30 seconds remaining.
Occupations in beauty such as cosmetologist, barber, nail technician, and esthetician are licensed occupations regulated by each state. My concern, shared by beauty schools and beauty professionals, is that a rewrite of the gainful employment rule will fail to properly account for unreported tip and self-employment earnings, and as a result will force programs with low graduate debt and low graduate default rates to close. The earnings measure also does not account for part-time workers or for the earnings increases that accrue over a career as a licensed professional builds a client base. For this reason, I emphasize my request that any gainful employment rule properly account for the earnings issues that are present in this industry. I also request that regulations are applied equitably.
Your
and do
time
not-
is completed.
Sandra, thank you very much for
Thank you.
joining this afternoon. Okay, with that, that concludes today's session. It is 4:03 p.m. Tomorrow's agenda will be aggressive, hopefully, that you wrap up financial responsibility, move directly into certification procedures, and depending on how all that goes, maybe even open the tip of the iceberg on the change of ownership control. So with that, have a great night, and we will see you in the morning.